Happy New Year. As we welcome 2024, we begin season 3 of Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans, and this is episode 1 updates. We'll talk about the new developments and cases we've covered in seasons 1 and 2, including Texas versus Rodney Reed, Oklahoma versus Richard Glossip, Texas versus Melissa Lucio, and North Carolina versus Molly Martens Corbett and Thomas Martens. We'll also talk about some of the cases that we intend to look at in season 3. And for everybody that noticed, I let Roberta out of the computer this weekend. I will have her back on our next recording date. I just picked the wrong file, so I ran with it. Good
Well, Happy New
afternoon.
Year. Good
Happy New
afternoon.
Year. All right, well, let's get started on our updates. And of course, Rodney Reed. This is kind of in order of when we covered them. No
Yeah, I think that was the
particular
first case we did, if I recall.
Julius. Well, that might have been the first case you and I did. I
Yeah,
did a Julius Jones episode with Amy and Jennifer Harmon,
right.
Amy Kingery and Jennifer Harmon. But yeah,
Yep.
Texas versus Rodney Reed, I think, was our very first. So as always, it's about Stacy Lee Stites, who was 19 years old when she was killed by Rodney Reed on April 23rd, 1996. Reed was tried and sentenced to death in May of 1998. So Stacy's murder, there was nearly a year between the murder and Reed's eventual arrest, which came about as a result of a DNA match to unknown DNA found in and on Stacy's body in the criminal investigation. Also, nobody during that 1 year period ever said anything about Stacy being in a relationship, secret or otherwise, with Rodney Reed, including Rodney Reed. Reed's conviction was affirmed on direct appeal on December 6, 2000. He had an initial state post-conviction case, and I recently found the findings of fact and conclusions of law for that case, which we will look at the next time we talk about Rodney Reed. But that was denied by the district court on October 1st, 2001. Ultimately, it was also denied by the Texas Court of Criminal Appeals. His case has been to the United States Supreme Court on 3 writs. The first one was after his first state habeas was denied. And that was denied in October 9, or his direct appeal, rather. That was denied on October 9th, 2001. He appealed denial of federal habeas relief. That was denied on November 3rd, 2014. And then he appealed the denial of his 8th and 9th state writs, which was denied on February 24th, 2020. So anybody who claims Reed is not getting due process of law has no clue what they're talking about.
Yeah, it's always seemed like he's gotten more process than him and
It,
Glossip seem to
it,
just have gotten more attention and time from the court system
yeah.
than most other defendants.
So I'm not going to go through. He's had basically 9 state post-conviction writs. They've all been denied or dismissed. I'm not going to go through each of those. He's had a federal post-conviction, federal habeas corpus claim that was denied, and that denial was affirmed by the Fifth Circuit Court of Appeals, and he appealed that to the U.S. Supreme Court. He has now filed. Well, he filed a successive writ of habeas corpus at the Fifth Circuit Court of Appeal in 2019 ahead of his proposed execution date. That matter was dismissed. Basically, he was filing the same claims that he was filing in the state 10th and 11th or 10th writ with the federal, trying to get a new federal habeas claim. That was dismissed without prejudice pending resolution of his Court of Criminal Appeals claims in his 10th writ. And then we also know his challenge of the DNA, denial of DNA testing by Texas state courts, challenge in federal court. The U.S. Supreme Court granted habeas corpus, or I'm sorry, my brain is not working right today. They granted his petition for writ of certiorari, and on April 19th, 2023, we begin our update now. These are developments since our last look at the case. That was granted, and on April 19th, 2023, basically the U.S. Supreme Court reversed the Fifth Circuit Court of Appeal in a 6-3 decision, finding that Reed's Section 1983 claims were timely filed. That was the basis for the Fifth Circuit's affirmance of the U.S. District Court's dismissal. Now, a lot of people are portraying that as this great big win for Reed, but in reality, all it means is that the claims go back to the Fifth Circuit. They look at the dismissal of the 1983 case again, and they decide whether to affirm it on other grounds or to reverse and remand it back to pursue in the federal court. Even that is not going to get him DNA testing, because the federal court can't grant him access to DNA testing outside Texas state law.
Right. Yeah, feel like they're just throwing stuff against the wall.
Yes, they are, but they throw it against the law and the wall, and it buys them 5 years, 6 years. So, it's working to extend his life, but as with Larry Swearingen, his time will run out. Also, on May 23rd, 2023, the U.S. Supreme Court issued its judgment, which awarded costs in the amount of $1522.50 to Reed, based on the successful challenge in the U.S. Supreme Court petition. Then, of course, I think we talked about this in its own episode. His 10th state writ was denied on June 28, 2023 by the Texas Court of Criminal Appeals, basically finding that Reed's latest attempts to demonstrate his innocence, both substantively and under ex parte elizondo, and procedurally under Article 11.071, Section 5A2 of the Texas Code of Criminal Procedure, do not warrant relief. We also explain why Reed has failed to prove that the state suppressed material evidence at the time of trial in violation of Brady versus Maryland, or that the state presented material false testimony at trial in violation of ex parte Chabot. Ultimately, we deny relief and dismiss any remaining claims as abuses of the writ. Again, we talked about that in more depth last time, so that's basically the outcome. Of course, we know Reed's attorneys disagree with the facts on which the district court based its denial and on which the Texas Court of Criminal Appeal based its denial. They are free to do that, but that's, too bad, so sad, sucks to be you. It's not unlikely to get him. It's not likely to get him very far.
Yeah. Have there been any real major updates since we last talked, or is it just sort of in the waiting period?
Yes, there is. We also have the 11th writ, which claimed that the state hid evidence, but that also was dismissed, because basically all these people, Reed could have gotten this evidence and presented it at trial. It wasn't hidden from him because it's not substantively proof that there was a relationship. It's repeating rumors that people had heard. And then finally,
Right.
the source of one of the rumors saying, I didn't say that. So, all right. So now we have in federal court, Reed has filed a motion for reconsideration on September 8, 2023, seeking to reopen his original federal habeas claims based on the fact that Reed's evidence has dismantled the state's theory, which is their opinion, but no court has found that to be true. The court's credibility findings are unsupported by the record and should be reconsidered. The court recognizes the trial court failed to make impartial credibility findings and then relies on those findings anyway. And the court's independent credibility assessments fail. Now, this is challenging the original 2013 memorandum opinion that dismissed Reed's federal habeas claims. The court must reconsider the insurmountable and legally unsupported burdens it imposed in denying relief, and the court's attempt to compare Fennell's sex offense conviction and his abuse of his official authority to Mr. Reed's other bad acts is a fundamental error. So they're relying on these new claims that have been rejected by the state courts to try to start his federal habeas claims over again and bring in these claims in addition to the previously rejected evidence that was brought in. My apologies. I skipped ahead. This was in the Court of Criminal Appeals that they were trying to get the Court of Criminal Appeals to reconsider its denial of relief. I jumped ahead. Spoiler alert. Then they filed an application with the U.S. Supreme Court because they did intend to file a U.S. Supreme Court writ. The extension of time was granted by the U.S. Supreme Court. The TCCA dismissed the motion for reconsideration. Reed did file a second application for extension of time in October of 2023, which was also granted. He filed his briefing in his Fifth Circuit appeal of the 1983 claim. Briefing has concluded and there's a decision pending, but it hasn't been rendered yet. Then on November 28, 2023, he filed his U.S. Supreme Court petition for writ challenging the state court's handling of his 10th and 11th, or his 10th state writ. The state has received a motion for extension of time, and their brief in opposition is due on January 29th, 2024. Now, what I was alluding to earlier is this is the real thing. Reed has filed a motion for relief from judgment pursuant to Rule 60 of the Federal Rules of Civil Procedure on December 22nd, 2023, seeking to set aside the judgment in his federal habeas petition and then presenting reasons why the judgment is defective, a lot of it based upon the rejected claims in his state court post-conviction. He wants also a motion for discovery to further develop the factual record of his motion for relief from judgment pursuant to Rule 60, and that the state filed an unopposed motion for extension of time to respond, and that was granted, and their response is due on or before Friday, January 19th.
Oh, so that's coming up.
Yeah. So that's where Reed's case stands. He's got the Fifth Circuit appeal still pending. He's got the U.S. Supreme Court writ challenging the 10th denial of his 10th state court writ, which is unlikely to be granted. And then he's got this new challenge to his federal habeas court dismissal or denial of relief. That's also unlikely to succeed. It very, very rarely succeeds. And given that the state court record of what he's arguing as the basis is pretty thoroughly against him, I don't think he's going to succeed.
Yeah, those habeas claims seem always just so broad. It seems like under a habeas, you can just basically file anything. I know that's not true, but I'm just always amazed that the habeas it's so broad. Like all of these appeals seem to fall under habeas.
Yeah, and a creative attorney, yeah. But the federal habeas is once you've been through state direct appeal and state post conviction, then you bring those claims to federal court, and the federal court can only grant relief if the state court handled a claim or claims inconsistently with federal Supreme Court holdings. So, if it was truly in violation of Brady and the state court didn't handle it properly, then yes, it could be reversed. But Reed doesn't have any of that going for him.
Right.
So, because the only good thing is that Reed's attorneys are misrepresenting the facts, misrepresenting the record, and digging their heels in and arguing that they're right and sticking their fingers in their ears and pretending that anything that is inculpatory as to Reed doesn't exist. But they're not effectively refuting any of the evidence inculpatory as to Reed. They've never addressed those 2014, 2015 DNA results. They just pretend they didn't happen. And they argue, contrary to the record, that Reed's conviction is based on a few sperm cells found inside Stacy's body. When the reality is it's sperm cells inside her body, saliva on her breast, stain on her panties, stain on her back brace, and stain on her pants. In addition to rectal swabs and breast swabs and all that other stuff. So they're unlikely, as with Larry Swearingen, they're unlikely to ultimately be successful. The time will run out. The TCCA will reject. The next time bullshit is filed by Rodney Reed, the TCCA is more likely to reject it and not stay in execution, and he will.
We've talked about this before, but I mean, this to me, of all the innocence fraud cases, this to me seems like the most ridiculous. I mean, I mean, in some of the cases, okay, you can sort of make arguments. I don't necessarily believe it, but okay, I can kind of understand why people think that way. This one, I honestly can't imagine why anybody, thinks he's innocent. I mean, not only because of the case itself and all the evidence, but, all the other, the history surrounding him. I mean, this seems like actually the most ridiculous that there's actually still people out there that think he's innocent.
Well, that's because the majority of them ignore anything that doesn't fit with their preconceived notion of racial bias and unfair trial, and they pretend that he was framed. So if there's any inculpatory evidence, it's because Jimmy Finnell planted it. Even they don't necessarily articulate that, and they can't articulate that.
We joke, it's like, I mean, not to be flippant, but it's like, Jimmy Finnell and Terry Hobbs are both, super criminal masterminds that can be in 5 places at once and create evidence, plant evidence to trick all law enforcement. They're just masters of trickery and illusion.
Yeah. All right. So that is Reed. We will, of course, revisit his case when there is something substantive like Fifth Circuit or U.S. Supreme Court movement or movement in this latest federal habeas challenge. He's also likely to file an application to file a successive federal habeas petition at some point, more likely than not, while he's after he gets another execution date.
Right.
So,
Yeah, he will
in hopes
definitely
that
keep.
that'll get him another stay.
Yep.
All right. Next case is Texas versus Melissa Lucio. She was convicted of the murder of her 2-year-old daughter, Mariah Alvarez, on February 17th, 2007. She was convicted and sentenced to death in July of 2008. Her direct appeal, her conviction and sentence were affirmed on September 14th, 2011. Her writ to the U.S. Supreme Court was denied on June 4th, 2012, and she had a subsequent writ challenging I think it was challenging denial of her federal habeas claims. That was denied in 2021. She has had 4 state post-conviction writs. The first 2 were denied. The third was for mandamus relief, which was conditionally granted. There was a motion for stay of execution denied and a second motion for stay of execution granted, and certain claims made on her 5th state court writ were remanded for further development in the trial court or the district court. That was a false testimony claim, a new scientific evidence claim, an actual innocence claim, and Brady violation claim. Those have been litigated in the Cameron County Court. However, I don't have access to anything substantive that would tell me what the outcome was. And then ultimately in 2022, the supplemental record in her third writ of mandamus was filed and no mandate issued. So that was basically eventually denied once the subsequent record was filed. She's also had a petition for writ of habeas corpus in federal district court, which was denied on a motion, which was granted. Let's see. The respondent's motion of summary judgment was granted and a COA was denied. The Fifth Circuit reversed and remanded after granting a partial COA on her claims regarding failure to provide a complete defense, and then an en banc review by the Fifth Circuit in 2021 reversed that decision and affirmed the district court's denial of relief. That's what was appealed to the U.S. Supreme Court, which was denied. Now, on April 28, 2022, after her stay of execution was granted, there was an order of assignment on motion to recuse, which referred that motion to Judge Mario Ramirez in the 332nd District Court in Hidalgo County. I don't know why I said, well, she's in Cameron County. This went to Hidalgo to decide whether to recuse the Cameron County judge. The motion to disqualify was ultimately denied on September 28, 2022. The parties entered agreed findings of fact and conclusions of law on first subsequent writ of habeas corpus on December 20th, 2022. But again, I don't have that. I don't know what it says. And there's nothing in the media about it either. There was a joint advisory of notice of filing an exhibit by Lucio and the DA. And my guess is that there's been some agreement that hasn't been reported.
Oh, that makes sense.
Nothing has been filed at the Court of Criminal Appeals. And like I said, I don't know. I probably at some point later this year, I probably will reach out to the Cameron County Court and try to get a copy of these findings of fact and conclusions of law. But if it were really positive for Melissa Lucio, I don't understand why it's not being reported on.
Yeah, it seemed like that would be a big story, right?
But maybe this is a situation similar to Glossip where the fix is in, and so they're not reporting on it because it's going to anger people.
Right.
So that is basically it's that case is literally in limbo right now. And more than a year after the agreed findings, no other movement has happened.
Wow.
So, the next case we're talking about, the post Alfred DNA testing request made on behalf of Damien Eccles. I have WM3, but it's not really on behalf of all three. It's only on behalf of Eccles. The victims in that case are Steve Edward Branch, 8, Christopher Mark Byers, also 8, and James Michael Moore, also 8. They were murdered by Eccles, Baldwin, and Miss Kelly on May 5th, 1993. Miss Kelly was tried January to February 1994 and was convicted and sentenced to life in prison plus 40 years. That would have amounted to no parole, because on an indeterminate sentence at that time in Arkansas, you could not get parole calculation if you had a life sentence. I think they changed the law at one point so that a life sentence was X number of years. And then if you had an additional term of years, your calculations were based on your total sentence. But that wasn't in effect at the time Miss Kelly was sentenced. Then Eccles and Baldwin were tried between February and March of 1994. They were both convicted. Baldwin was convicted of 3 counts of first-degree murder and sentenced to life without the possibility of parole. Eccles was sentenced to death. He was convicted of 3 counts of capital murder and sentenced to death. Their convictions and sentences were affirmed on direct appeal in 1997. Miss Kelly's were affirmed in 1996. Post-conviction, Eccles had a Rule 37 action. The claims were denied by the trial court and affirmed by the Arkansas Supreme Court. He had a couple of writs of error coram nobis that were unsuccessful. He had a federal writ of habeas corpus that was stayed pending outcome of his motions for new trial in state court. Baldwin and Miss Kelly each had Rule 37 claims which were pending at the time. And Eccles, Baldwin, and Miss Kelly's motions for new trial were pending. On August 19th, 2011, they entered Alfred pleas. And they, for lip service, said they intended to pursue exoneration from the outside, but then they basically went and partied on a rooftop in Memphis. Eccles wrote a couple of books. Jason started posting on Twitter with some Austin-based innocence group, but they didn't ask for DNA testing. They didn't do anything. There was a little sideshow in 2013 where an attorney on behalf of Pam Hicks started making accusations against David Jacoby and subpoenaed him to appear at a sideshow hearing in West Memphis or in Marion. But nothing ever came of it. And it was based on alleged admissions of guilt by Buddy Lucas, who was alive but not called to testify, and L.G. Hollingsworth, who died in 2000, I believe. So, and these were from convicted felons who had waited years and years and years to come forward, but who had also been incarcerated with Baldwin. So the credibility of those statements is, if that anybody believes them, is ridiculous. And again, they never sought direct testimony from Buddy Lucas about his alleged admissions, which is a humongous flaw.
Right. Well, it's just people throw it out there, and it's like, who's going to find the real killers first? These guys or OJ?
And then, of course, in the next sideshow was Sideshow Bob, otherwise known as Bob Ruff, who made an Oxygen series, who did a quote investigation, unquote, on his podcast, where he made a lot of speculation and a lot of leaps, and reported what fit with his preconceived opinions and ignored anything that didn't fit his preconceived opinions, and then declared them innocent, became great friends with them, visited them, interviewed them with the exception of Miss Kelly. Then he gets the oxygen special, and he just kind of doubles down on everything. And he also starts floating this idea of using MVAC to collect evidence and engage in DNA testing. But the only problem is everything he wanted to test had been subjected to DNA testing and no DNA was recovered. While in theory, MVAC might be able to recover more from the evidence, it's not guaranteed. And especially given that the evidence has been handled, subjected to testing, handled, subjected to more testing over the years, it's very unlikely that MVAC is going to yield anything conclusive. Probably, especially due to the time that's passed, it's going to yield maybe a few partial profiles from evidence that didn't previously yield DNA, or partial profiles identical to what's already been recovered. But MVAC is not DNA testing. MVAC is an evidence collection vehicle. And it's also been around long enough that if they wanted to use it, they could have used it prior to the Alford plea.
Yeah, no, exactly. Well, it's just more confusion. It's just a more
they could have asked for it and used it shortly after the Alford plea.
Right.
So years go by, 5 more years later, finally, after lying to the media and trying to go through the back door to get testing between Bob Ruff and attorneys for Eccles, finally Eccles filed a petition to conduct additional DNA testing in January of 2022. The state responded. I believe they challenged jurisdiction. And then when the hearing was held, they kind of dropped that challenge and just let it go forward in Crittenden County. And the judge denied the request on the basis that Eccles, Baldwin, and Miss Kelly, their SIS agreements had expired, and therefore they were no longer in the custody of the state of Arkansas, nor were they in jeopardy of being returned to the state of Arkansas's custody. So the circuit court did not have jurisdiction to grant habeas corpus relief to a person not in custody, and that therefore the request was denied. Again, the state more or less at the hearing dropped its jurisdictional challenge. Eccles filed a notice of appeal on July 22nd, 2022. He filed an appellant's brief on January 9th, 2023. On February 21st, 2023, the state filed a motion to dismiss the appeal. Basically, they raised all the challenges of jurisdiction for Craighead, for Crittenden County, and also jurisdiction based on the fact that Eccles is no longer in custody, because that meaning the court now lacks jurisdiction at any rate to grant DNA testing. Eccles, of course, filed a response to the motion on March 1st, 2023, and more or less played everything Eccles has filed plays to the court of public opinion.
Right, because that's what I mean, he's really right at this point. He's just trying to kind of he's losing, his star's kind of faded. No one's buying his magic books and his weird paintings. And so he's just, the celebrity, Johnny Depp is, getting pooped on by Amber Heard, not giving him money. So he's, looking to stay in the public eye and finding some reason for people to keep him famous, and for people to keep donating to his random GoFundMe's.
Yes. And of course, we have to remember the new rallying cry of Innocence Project, in addition to lay people who have bought into the innocence fraud movement, is that somehow there is a right to exonerate yourself at any time
Right.
when you've been convicted of a crime,
Right.
and by any means, which is not true. There is no right. The U.S. Supreme Court has said there is no right to DNA testing under due process.
Right.
So until they change that, there is no right. But they're trying to, again, they're trying to kind of shoehorn that
Well,
into becoming a right.
when I think this case in particular, I mean, this one is bad because there's so much, libel of, the step parents online. I mean, all these crack jobs claiming that, there's one suspect in one movie, then the next movie there's another alternative suspect, and there's people that actually believe that one of the stepfathers did it. It's
Mm-hmm.
crazy.
Yeah. So, all right. So May 15th, 2023, the state also filed its appellee brief. Eccles again filed a reply brief. And these are the headings, which is just showing they're just playing to the court of public opinion. Act 1780 says what it means and means what it says. There's no territorial jurisdictional impediment. An Alford plea is an accommodation, not an admission. The state waived its technical objection to verification because they basically argued that Eccles didn't properly verify his petition for testing in the first place. Of course, the usual cast of characters has filed amicus briefs. Their attorneys have also sought pro hoc vice admission before the Arkansas Supreme Court, and those include the Center for Wrongful Convictions, exonerees, including Amanda Knox, Adnan Syed, and Marty Tankleff, and the Innocence Project. Some of the pro hoc vice admissions include Stephen Braga, who represented Eccles, Stephen Dreisen, and Laura Nyrider, who have represented Brendan Dassey, and Marty Tankleff, who was exonerated to some in the murder of his parents in New York State. That is still a decision from the Arkansas Supreme Court is still pending. Given the time it took them to decide Stacey Johnson's DNA appeal, I'm not expecting a decision from them anytime soon. Because they took a very long time to decide Stacey Johnson's DNA appeal. After he had been granted DNA testing and it didn't exonerate him, and he was challenging that. So, all right, next case is Oklahoma versus Richard Glossip. He was convicted of the January 7th, 1997 murder of Barry Allen Van Treese, age 54, a father of 7, a husband, a brother, a son. And in fact, the anniversary of that, the Van Treese family's loss of Barry was just last week. Yesterday was the anniversary of Haymon Lee's murder. So that's another sad day.
That's right. Sorry, that's right. I forgot it was.
Mm-hmm. Yeah.
No, we haven't really talked about that case, but that's still crazy that nut job,
Yeah.
corrupt
Yeah.
prosecutor in Baltimore let that killer go free. I swear, it's like we're justice by DEI and podcast popularity. It's crazy.
Yeah. Yeah. Most definitely. That is where we're headed. And it's really ridiculous. Because I respect, even if I don't agree with it, I respect the prosecutors because they know what they're talking about when it comes to the legal proceedings. and the legal burdens and the burdens of proof. And a lot of these people, like Bob Ruff, does not understand. Once you're convicted, the presumption of innocence goes away, and you bear the burden of proving that you are not guilty or you are actually innocent. The state does not bear a continuing burden
Right.
to continue to prove your guilt over and over and over again.
Right. Well, I mean, in fairness, when Bob was a fire chief, people embezzled from his department right from under his nose, and he didn't realize it. So his skill isn't, and that's why he got
That's true.
fired. So
That's
his
true.
skill as an investigator is limited. But I'll be honest, I got to credit. I mean, there's never been a less talented guy that has transitioned his lack of talent into a probably pretty good career. So kudos to him for tricking a bunch of people.
Yeah, I'm just waiting for him to lose it and say something that ends up getting him canceled.
Yeah,
And
probably.
hopefully that will happen very soon.
Yeah.
Um, so, uh, okay, so Glossip and nobody's ever said that Glossip wielded the bat that killed Barry Ventrise. Always, from the moment they found Barry Ventrise's body and the moment they started questioning Glossip, they knew he knew something. They knew he knew more than he was saying. And that is because he knew that Barry was dead at 5:30 that morning or 4:30 that morning when Justin Sneed told him Barry was dead, because Justin Sneed said, I killed him. Now, if you have nothing to do with that situation, what you're going to do is you're going to go to your phone and you're going to go call the police and you're going to say, my maintenance man just killed my boss and I want police out here right now because I want to deal with it. But instead of doing that, Glossip went back to bed and lied to his girlfriend. He lied about how the window got broken. He lied about who the room was rented to. He lied about who was in the room. He kept the maintenance people or the housekeeping people from going into the room. He claimed he saw Barry to 3 or 4 different people that morning, when he knew at the time he made the statements that Barry was lying dead in room 102.
Right.
And all those things lead to the belief that Glossip had something to do with this murder, which was eventually, when Justin Sneed was caught a week later, Justin Sneed's the one who said, yeah, he wanted me to kill him and I killed him. And when Justin Sneed was caught, Glossip was sitting in jail on an obstruction or failure to report type accessory after the fact, I think it was. But once Justin Sneed was arrested, they knew that Glossip was involved and directly involved. So Glossip's first trial, he was convicted on July 17th, 2001, but that trial was reversed and remanded for a new trial due to the ineffectiveness of his trial counsel. And I think we've talked about that in more detail. I'm not going to belabor it here. He then went to trial again in June of 2004. He was found guilty of first-degree malice murder and sentenced to death. His direct appeal, that conviction and the sentence were both affirmed on April 13th, 2007. He filed a writ with the U.S. Supreme Court, which was denied on January 28th, 2008. He has filed 5 state post-conviction writs, all of which have been denied, as have his requests for hearing and discovery. He has filed a federal habeas claim, which was also denied, and the 10th Circuit affirmed that. He has filed subsequent writs at the U.S. Supreme Court related to those denial of those claims, that was denied. He filed a challenge to the use of midazolam, and that was denied. or that was affirmed, and that actually stalled executions in Oklahoma for some time. The challenge, executions in Oklahoma could go forward after the affirmance, because basically they affirmed the finding that midazolam was not a violation of the Eighth Amendment. Anyway, that's why I hate abbreviating these things, because I lose track of what something meant. And then he filed another state post-conviction, a writ.
He's filed so many, it feels like every other day he files some motion.
He filed a state post-conviction writ that was denied in 2015. He challenged that with the U.S. Supreme Court. That was also denied. But the execution that was scheduled to go forward on September 30th, 2015, did not go forward because the state had received the wrong execution drug and had used it to execute Charles Warner, which led to yet another lawsuit by Glossip and other death row inmates. There was a consent order or consent judgment where the state agreed not to set any more execution dates until it had updated its execution protocol and ensured that they would check the drugs that they received prior to using them. They did do that, and then they were able to get their updated protocol. I think that was in 2020. Well, then Glossip and the inmates filed a challenge to the use of midazolam in federal district court. That was denied in June of 2022. The federal district court found that that did not violate the Eighth Amendment as they claimed. That decision was affirmed on October 19th, 2022. And that decision is final because a writ was not filed with the U.S. Supreme Court, and that made their writ was due January 9th, 2023. They didn't seek an extension, and they didn't file a writ. So probably because they were pursuing other avenues. Then in November 2022, the court entered an order approving a budget for all clemency and subsequent proceedings on behalf of Glossip. Then Glossip filed on January 3rd, 2023, a petition for writ of certiorari challenging the denial of his 2022 state court post-conviction. That was 2 actions. And so this writ is kind of a hodgepodge of pieces of each of the actions. And basically what they're challenging is whether a court may require a defendant to demonstrate by clear and convincing evidence that no reasonable fact finder would have returned a guilty verdict to obtain relief for a violation of Brady versus Maryland, and whether suppressed impeachment evidence of the state's key witness is per se non-material under Brady versus Maryland, because that witness's credibility had been otherwise impeached at trial. The Supreme Court ordered the record, which was received on February 21st, 2023. Then, of course, we've talked about the report by Rex Duncan, who was supposed to do an independent investigation, but did not do an independent investigation. He basically went to Don Knight, Reed Smith, Jackson Walker, and Crow and Levy, all advocates for Glossip, to get his information and get his marching orders. He had several in-person meetings with Don Knight and Amy Knight, and they, of course, gave him the pro-Glossip facts to rely on in his investigation. His report, in fact, regurgitates the pro-Glossip spin on the facts and history of the case, and parrots conclusions that Knight and Reed Smith as to Glossip's innocence. So basically, the report was not an independent examination of the Glossip case, as McDougal and Humphrey did before him. Duncan started with the conclusion that Glossip was innocent and cherry-picked those facts that fit that conclusion to support Drummond's decision to abandon the Van Treese family and become an advocate for Glossip. Glossip filed a second petition for writ for state post-conviction relief No, I'm sorry. He's challenging the Oklahoma clemency procedures. Since that action is still pending, I'm just going to let it. We're just going to talk about the fact that he's trying to challenge. Basically, what he wants to say is he wants a court to say if somebody recuses, a member has to be appointed to sit in that person's seat to review pending clemency decisions. So if 3 out of 5 have to recuse, then 3 people need to be appointed. So there's always 5 members. Of course, that's not really how pardon parole board works, but okay.
The point of having that change, what's the advantage for him?
Well, because his argument is that when a person goes before a 4-member panel, what he has to prove or his burden of persuasion goes up because you have to have a majority vote.
Got it.
And if it's 2-2, it's denied. So if you can't get 3-1, then it's denied.
Gotcha.
There was a clemency hearing on April 26, 2023. And as we saw, A.G. Drummond abandoned the Van Treese family and supported clemency for Glossip, including ceding his time to Glossip advocates. The Van Treese family were forced to speak out against clemency without the AG's support. And Derek Van Treese's statement, or part of his statement, which was very eloquent and heartbreaking, he finally said, "Enough is enough. The time is now. I urge you, I beg you to allow justice to finally be served through the word of law and the will of the people by denying clemency." Of course, like I said, the vote was 2-2 and clemency was therefore denied. Glossip filed a petition for writ of certiorari with the U.S. Supreme Court challenging the OCCA's April 20th, 2023 denial of his post-conviction application, which I didn't list on this form. Sorry, folks. We went through it in detail when we talked about Glossip the last time, so people should remember. It's kind of a ridiculous claim because it's that the state didn't tell them that Snead was prescribed lithium for mental illness, and that they didn't tell them that he was being treated by a psychiatrist at the Oklahoma County Jail, and that when he said, "I ain't seen no psychiatrist at trial," they didn't immediately correct that and say, "Oh, yes, you have." But they have known for years that he was prescribed lithium. And they've gotten these medical opinions said lithium is not prescribed for anything but psychiatric illness. So they've known he had a psychiatric problem. But again, his psychiatric issues are not, they don't have anything to do with whether Glossip is innocent or guilty.
Exactly. It doesn't have any impact on his guilt or innocence.
They're trying.
Probably makes it more reasonable that he was able to get him to commit the murder for him.
Exactly. And well, what they're trying to say is that it proves that his confession and his involvement of Glossip is all false. Because they're trying to claim that he made a false confession. And that he was coerced into naming Glossip. And, they've got this wild and incredibly stupid theory, and they just won't let it go, even though it's very easily refuted and has been very easily refuted by the state every single time they've tried to argue it. So that was the writ. The question presented was whether the state suppression of key prosecution witnesses' admission he was under the care of a psychiatrist and failure to correct the witness's false testimony about that care and related diagnosis violate due process of law, whether the entirety of the suppressed evidence must be considered when assessing the materiality of Brady and Nappy claims, and whether due process of law requires reversal where a capital conviction is so infected with errors that the state no longer seeks to defend it. But again, the state is not defending it because Drummond has probably gotten some really great blowjobs from Ken McDougal. And so whenever somebody says Glossip, Drummond gets excited. And all the blood rushes from his northern brain and goes to the southern one. And so he can't think straight.
Oh, it's amazing.
And yeah, I said it.
It's actually perfectly. It makes a lot of sense.
I mean, that's the only reason I can think for an attorney general to come into office. And when it's within 3 months, begin to advocate for a convicted murderer, even in the face. I mean, I can understand if you maybe think that some things that were withheld by prior AGs kind of toe the line. But I mean, to argue that these burdens on the state about the psychiatric treatment and the lithium and the doctor's name to glom onto Don Knight's retarded. Well, no, that's an insult. Not to Don
Knight. Yeah, to insult the special needs people.
Yeah. To Don Knight's, like, I don't even know what to call it because it's so fictional. That's what it is. It's speculative because everything Glossip has filed in these last 4 writs has been entirely speculative. I mean, they presume to know what people intended without ever having actually talked to those people. So, it kind of like, I'm wondering if David Fisher is secretly working for Richard Glossip. Because it reminds me sometimes of David Fisher's wild and crazy stories.
Right.
So Glossip has amended his petition challenging the clemency procedures. We're not gonna talk about that right now. Now, the U.S. Supreme Court did grant a stay of execution on May 5th, 2023 for Glossip, pending review of his writs in 22-6500 and 22-7466, which are still pending as we speak. And the notice of stay of execution was filed in the pardon parole challenge. Now, McDougal and Humphrey apparently got a bright idea, but since they don't have a full brain cell between them, their execution of this bright idea didn't work out so well. What they did is they got Christina Vitale at Jackson Walker to seek records from multiple district attorneys and members of the Pardon and Parole Board. And then they obtained some of those records, and they used those records to claim that there was some impropriety in the clemency hearing. Even though, more likely than not, if Glossip gets another execution date, he's going to get another clemency hearing, even though he's not supposed to get one. But whatever. Or perhaps they're trying to use that in the challenge to the clemency proceedings and the other state court matter, or they don't really know what the fuck they're doing. They're just two bumpkin idiots that are going to try and get on this Glossip as an innocent bandwagon. So they received some records, but one of the district attorneys who didn't immediately respond was by the name of Jason Hicks. He is in, I think it's District 5, and he's several counties. He attended the clemency hearing with other DAs in support of the Van Treese family personally, not as a DA. So on the 5th of July, Vitale sent him an email following up on her request for records. On the 6th, he responded, and he said that his office was reviewing the request and they would respond shortly. If he didn't respond directly, someone from his office responded for him. And then on the 13th, an attorney by the name of Seifers in Hicks's office, or Cyphers, he transmitted responsive documents to the Opens Records request to Hicks and advised that the text messages they were seeking were exempt and would not be produced. Vitale followed up with a second email on July 24, 2023, looking for the response from that was sent on July 13th, but it was apparently sent by mail and not electronically. Then on the 27th, she followed up with a letter that advised Hicks that his text messages were not exempt and providing authority that allegedly supported that position. On September 8th, Cypher sent another email referencing a call between himself and Vitale and advising that because Hicks had no authority to act in Glossip's case, any communications he may have had were an expression of his personal opinions, and any attempt to characterize Hicks's involvement as state business is simply fiction. On September 11th, Vitale sent a second request for records, which were the expense and reimbursements made to Hicks for the period of April 24th to April 28th, and then requesting additional expense records from February 2023 to May 2023. On the 24th of October, Cyphers produced the requested expense records and reimbursements, and this included Hicks's personal check dated June 6, 2023, in the amount of $111.35, which reimbursed payment for his mileage for his trip to Oklahoma City on April 26, 2023, because the trip was not to conduct DA's business. Of course, later, speculatively, someone will argue that he only did that when he got the public records request from Vitale. But I can attest to that. I have entered personal mileage. I have entered personal expenses. I even entered a personal airfare reimbursement for one of my attorneys because I thought that I get copies of his, expenses, and I thought that was for something for business.
I just made a simple mistake. Yep.
Luckily, I had a question, and so I asked the question, and he said, "Oh no, you should not have that. that was totally personal. Sorry about that.
Yeah.
You should not. Don't worry about that one." And I've had to call and say, "Oh, I entered this, and it's not, it's not really business. It's personal. It was personal. I didn't realize that I entered it by mistake." That does happen. So
yeah, we've all done that.
And like with him, if he goes somewhere, I automatically enter the mileage without him telling me to. And usually I know what file it's for, et cetera, et cetera. But this could have been as simple as he was in Oklahoma City. He was supposed to go to a ceremony for victims, and then he changed his plans and went to the clemency hearing.
Right.
And so his assistant entered the mileage for Oklahoma City because it was supposed to be DA business, but then it ended up not being DA business. So then an additional a supplemental budget of $27,580 has been approved in the federal court action for additional work on behalf of Glossip. So anybody who says Don Knight is entirely pro bono doesn't know what they're talking about. He's maybe not being paid by the state of Oklahoma, but he's being paid by somebody because he's got federal court authorization for reimbursement.
Yeah, there's an agenda. Somebody's paying him to come to a conclusion.
And then Glossip did file a second amended petition in the pardon and parole clemency challenge. That was supposed to have been stricken per agreement on October 26, 2023. So I'm going to check the docket later and see if it's ever been served. And so then on December 20th, 2023, McDougal and Humphrey, using an Oklahoma attorney, because Vitale is a Texas attorney, filed a petition for relief pursuant to 51 OS sections 24.A17B against Jason Hicks. And that's by Corbin Brewster at Brewster and DeAngelis in Oklahoma. They are requesting that the records sought by plaintiffs are public records for the purposes of the ORA. They want a declaration from the court that plaintiffs are entitled to prompt disclosure of the requested records, that defendants' withholding of public records responses to plaintiffs' first and second requests is unlawful. They want to grant an injunction pursuant to 51 OS 24A17 and or issue a writ of mandamus requiring defendants to immediately disclose all records requested by plaintiffs pursuant to the ORA and to award plaintiffs reasonable attorney's fees and costs in this action pursuant to 51 OS 24A17B2. Jason Hicks has followed it up with on January 5th, 2024, with a motion to dismiss plaintiff's petition for relief pursuant to 51 OS 24A17B with brief and argument in support. And basically, he's arguing that plaintiffs lack standing because they did not make the request. Christina Vitale at Jackson Walker made the request. And Christina Vitale did not say, on behalf of my clients, Kevin McDougal and Justin Humphrey. And the reason she can't say that is because she ain't licensed to practice law in Oklahoma. So she can't represent Oklahoma clients in an Oklahoma case. So hopefully that's going to get her ass in some trouble. If she tries to argue that she's their attorney, that's going to get her ass in some trouble. He argued that plaintiffs did not request any records and were never denied any records, and therefore they failed to state a claim upon which relief can be granted, and that this case is clearly frivolous, should never have been filed, is without legal basis, and must be dismissed, entitling defendant to reasonable attorney's fees upon his successful defense. Mr. Hicks has also promised that there will be discovery in this case, and so Kevin McDougal and Justin Humphreys are going to have to pony up some shit too. And I hope that he makes it as unpleasant as he possibly can for the two of them. Glossip's writs have been listed for conference at the United States Supreme Court on January 12th, 2024. So they're still pending. And we don't really know why. I've heard different theories, one of which is that the people who want to grant the writ are taking their time to issue their memorandum of opinions against the denial of the writs. That's one theory. But each of these has been on the docket. The first one has been on the docket for over a year. And the second one has been on the docket for a year in April. So I wish they would get this shit together. And finally, an order setting hearing was entered in the public records action. And that was entered on the 9th of January. And it's setting a hearing on the motion to dismiss on February 16th, 2024, before the Honorable Brent Russell in Stevens County District Court. All right, so our next case, Oklahoma versus John Hanson. His victims were Mary Agnes Bowles and Gerald Max Thurman, who were shot by Hanson and his co-defendant on August 31st, 1999. Mrs. Bowles likely died on that date. Her date of death is the date her body was found, which was September 7th, 1999. And Gerald Thurman died on September 14th, 1999. He was found and taken to the hospital and lingered for some time before passing away. Hansen was found guilty on May 22nd, 2001, of first-degree malice murder of Mary Bowles and first-degree felony murder of Gerald Thurman. He was sentenced to death in Mary Bowles' case and life in Gerald Thurman's case on June 8th, 2001. His direct appeal was decided on June 11th, 2003. His convictions were affirmed. His life sentence was affirmed, but his capital sentence was reversed and remanded for resentencing. On January 24th, 2006, his jury found 3 aggravating circumstances: previous felony conviction, great risk of death to more than one person, and murder committed to avoid prevent arrest, and sentenced him to death. That direct appeal was the sentence was affirmed on April 13th, 2009. His writ to the U.S. Supreme Court was denied on December 7th, 2009. He filed 3 state post-conviction writs, including a McGirt challenge, which was alleging that he's a member of an Indian nation and the state of Oklahoma did not possess jurisdiction to try him, either based on the area in which the crime was committed or his membership in an Indian nation. Those were all denied. He had a federal habeas claim, which was denied on July 1st, 2013 by the district court, affirmed July 30th, 2015 by the 10th Circuit. He challenged those. He filed 2 writs with the U.S. Supreme Court on the federal habeas, which was denied, and then the McGirt challenge, which was also denied. On December 13th, I think you remember, when his execution was set, the Federal Bureau of Prisons refused to transfer him back to the custody of the state of Oklahoma. The Oklahoma challenged that refusal on December 13th, 2022. The court denied that challenge, which was a motion for preliminary injunction, and dismissed the case for lack of jurisdiction. They filed it in Texas, where the Bureau of Prisons was. And I think the argument with jurisdiction really should have been that it should have been filed in Louisiana, where Hansen is. But at any rate, it was denied. The death warrant has expired. That judgment was not appealed, so it became final. And his execution date expired on November 10th, 2022, and no new date has been set. I doubt that Oklahoma will set a new date. I think what they'll do, federal system, you get credit for good behavior, but I don't think Hansen's release date is anytime soon. He's got a life sentence in federal prison. So I think what they'll do is they'll just bide their time. And then if he is by some chance released from the federal prison system, they will take him into custody, because he is supposed to come serve his sentence in Oklahoma. He's got a life sentence in Oklahoma and he's got a death sentence. He'll be transferred to Oklahoma, and then they'll set his execution then. Which is probably, what they really should have done is, before they started trying to set execution dates, they should have tried to get him transferred back to Oklahoma custody.
Right. Yeah, that would have made a lot more sense, and it would have been less.
And the Federal Bureau of Prisons, when there's no execution date, might not have had any. Although because he has a death sentence, they might have had a problem.
Right.
But I think it is pretty sad that the Federal Bureau of Prisons is undermining a state. And they have to remember, if you want somebody from state custody now, and it's Texas or Oklahoma or a state that actually carries out their death penalties, you're probably not going to get what you want.
Right.
Because if the person has a death sentence, the state is going to want to keep them right where they are. And if they decide to release them, or if they get overturned or whatever, then they'll give them to you. So And I don't know how he came to be in federal custody instead of state custody, unless his federal trial came after his state trial. So, but he is, as of January 7th, 2023, when I checked, George John Hanson, who is John Fitzgerald Hanson. George John is an alias, or John Fitzgerald is an alias. He is serving life at USP Pollock, which is in Louisiana, I think near Shreveport. All right. We've got North Carolina versus Molly Martens Corbett and Thomas Martens. Their victim was Jason Paul Corbett. He was murdered by Molly and her father on August 2nd, 2015. And let me say, so there's no doubt in anyone's minds, I do not believe that Jason ever abused Molly. I do not believe that on the night of the murder that Jason attacked Molly. I do not believe that on the night of the murder, Jason attacked Tom. I believe that Molly and Tom cooked this up to prevent Jason from going back to Ireland with Sarah and Jack. They murdered him. They worked out their story. They called for help, and then they told their story. And if you notice, Tom Martens, he tells it the same way every time, just like Jeffrey McDonald. Same sequence, same words, same everything. He doesn't vary it. He doesn't, oh, wait, and I remember this. It's the same sequence of events every single time, like he's reading from a script.
Right.
So
that's how you know they're probably
I do not
telling
believe
the truth because the story's too clean,
and
too perfect.
Yeah, exactly. And I also believe if there was any abuse in that marriage, it was by Molly against Jason and Jack and Sarah. And that's why Jason wanted to leave.
Yeah, sometimes if it's just too perfect, there's they're making it up because
So,
every story is gonna have to change a little bit just naturally.
Yeah.
Not in major details, but just if it's too perfect, likely made up.
So, I, from the outset, I believe this was second-degree murder. I believe it was probably first-degree murder because I believe it was probably premeditated a lot more than just the night of August 2nd. And there are so many things about that don't add up. Like Martens, who's a very rigid, scheduled person, showing up at the spur of the moment from Chattanooga, where they were, or Knoxville, where they were living, to North Carolina. They weren't planned to be there. And there are inconsistencies about the bat. He claims he brought it to give to Jack, but there was evidence that the bat had been in the house for a while. So, but anyway, I just want to make sure that people understand as I talk about events that I don't believe either of them as far as I could possibly throw them. They're liars. I think they're lying. And if they're not going to get justice in this world, they'll definitely get it in the next.
Right.
So they were convicted of second-degree murder on August 9th, 2017. They were sentenced to 20 years minimum, 25 years maximum each. They began serving their sentences on August 9th, 2017. At that time, their projected release dates were February 10th, 2040 for Molly and October 29th, 2039 for Tom Martens. Their direct appeal in the Intermediate Court of Appeal basically affirmed their conviction and found no error by the trial court. But, oh wait, no, sorry, my mistake. The Intermediate Court of Appeal actually denied their motions for appropriate relief. The trial court's denial of the motions for appropriate relief was affirmed, but their convictions were reversed and their cases were remanded for a new trial because they were not allowed to use hearsay from Jack and Sarah that would have proven abuse.
Right.
Essentially. And then the North Carolina Supreme Court on March 12th, 2021, basically affirmed that finding, finding it was an abuse of discretion for the trial court to exclude the statement that the victim's children made in their interviews with the Department of Social Services under the residual exception to the hearsay rule contained in Rule 803-24. Because the statements were trustworthy, they were material and probative, and their admissions served the interest of justice by enabling defendants to present an adequate defense. So they affirmed the reversal. So on April 1st, 2021, Corbett and Martens were released with bail granted pending retrial. At that time, they had served 44 months of their sentences, which was 3 years and 8 months. On January 3rd, 2023, they filed a motion for change of venue from Davidson County to Forsyth County. The court issued a gag order or imposed a gag order on the parties, attorneys, and families. And then on February 17th, 2023, granted the motion for change of venue and transferred the case to Forsyth Superior Court. Trial was set to begin on June 26, 2023. On April 19th, 2023, the trial was continued to November 6th, 2023. Now, it's not on my notes, my apologies, but I had read on social media and in different articles, and I got the impression Jack and Sarah, who are both, I believe Jack's a young adult and Sarah is just under 18. She's 17, I think. I got the impression, I inferred that they were going to travel here and testify in person.
But they didn't.
Well, no. What happened was toward the middle of October, end of October, basically a plea agreement was reached between Molly and Martens and the state. This is an excerpt from the plea documents that I found in an article because the records aren't available online, or I couldn't find them fast enough. If I get my hands on them, I will definitely go into more depth. Both defendants agreed to the lesser charge on the theory of imperfect self-defense or defense of another. District Attorney Gary Frank signed off on putting that in writing and dropped any mention of premeditation or malice. The words heinous, atrocious, and cruel no longer apply. Upon defendant's plea, the state concedes the defendant actually believed that defensive force was necessary, but contends that at some point during the encounter, that belief became unreasonable and the amount of force employed was excessive. The plea agreements, that's what the plea agreements read. On October 30th, 2023, Corbett entered an Alford plea, no contest to voluntary manslaughter. Martens pled guilty to voluntary manslaughter. Again, I do not believe by any stretch of the imagination that voluntary manslaughter is the right charge. I believe they're getting away with murder. And the only positive is they both are now convicted felons. And for somebody like Martens, who was in law enforcement, who had high-paying jobs in security with he was at Oak Ridge, the lab in Tennessee. He handled their security. That career is over.
Yeah.
And for him, a 25-year sentence would have been a death sentence.
Yeah, for sure. Yeah.
But again, I don't believe that that's what they did, and by any stretch of the imagination. But that's the agreement that they made with the court, the DA. The court accepted the plea. So that's where we stand.
Right.
Again, if I can get my hands on the plea, the actual plea document, I will look at, because there'll probably be more information, more detail. And yes, they're still singing the same lie. They're telling the same lie that they've been telling since August 2nd, 2015.
Yeah, it's terrible. You talk about it's just a travesty.
But I also think the reason they agreed to enter this plea is because Jack and Sarah were going to be able to testify live. And so those hearsay statements that they made, that Molly and her mother basically convinced them that they had to make, would not have been as impactful in their trials as these two orphan children.
Right.
And they're still trying to tell the lie about Jason killing his first wife, their mother.
Yeah.
Which is the most heinous.
I know.
That alone.
It's a tragic story. I mean, this woman
Mm-hmm.
just makes me mad.
Yeah.
I mean, she tricked him, and I mean, just from day one, just what a sham.
Yeah, I think that was. I mean, I think she was looking for money and security.
Yeah.
And children. And he fit that bill.
Yep. She totally used him and then killed him.
And then, I think she killed him to prevent him from leaving her and taking the kids with him.
Exactly.
So, but we have to remember early on, her plan totally failed because she didn't get to keep the kids and she didn't get to keep any of the money either. Right. And she got in trouble with the courts in the estate. So, there is a small justice.
A small, yeah.
But anyway, so they were sentenced on November 8th, 2023. Corbett was sentenced to 4 years, 3 months minimum, 6 years, 2 months maximum, as was Martens. Their projected release dates are June 27th, 2024, and that's because they're getting credit for 44 months served prior to the reversal of their initial convictions.
It's crazy.
And then Arizona versus the next case is Arizona versus Jodi Arias. I had that April 21st, 2020 opinion where the Lexus summary was identical to the March 24th opinion. And that was not my mistake. That was Lexus's mistake. So I went through the March 24th, 2020 opinion, addressed some of the issues raised by Arias. The 21st memorandum decision, April 21st memorandum decision, addressed 4 other claims. And those were that the defense offered no counter to the prosecutor's explanations for dismissal of jurors other than to contend the prosecutor had failed to prove gender-neutral reasons for his strikes, and there's no basis upon the record to conclude the prosecutor's gender-neutral reasons for the strikes were pretextual. The Superior Court did not clearly err by finding the state's peremptory strikes did not violate Batson. Juan Martinez was eliminating women with domestic violence history and women who were not sure about imposing the death penalty. The record reflects that Arias participated significantly during the trial, testifying for 18 days. And contrary to defense counsel's claim, Arias' smirking and memory problems during her trial testimony cannot reasonably be attributed to the stun belt because they were entirely consistent with her pretrial behavior and the theory of her defense, dissociative amnesia. Finally, even assuming the prosecutor acted in bad faith by inviting Arias to provide a physical demonstration of the victim's posture and movements, intending to thereby reveal the physical restraints, Arias sustained no resulting prejudice. After the invitation was extended, defense counsel immediately objected, and the court prompted the attending detention officer to remove the restraints before the prosecutor proceeded with the demonstration. Therefore, upon this record, Arias sustained no prejudice from the use of physical restraints at trial. The erroneous admission of Officer Friedman's testimony about the gun theft was harmless. Evidence of the apparent burglary and gun theft was corroborated by Detective Flores' testimony, and more importantly, the interrogation recordings that were admitted as exhibits, which allowed the jurors to directly assess Arias's admissions. Moreover, Arias testified unequivocally that she knew before her interrogation that her grandparents had reported their guns stolen. Given Arias's repeated and express admissions that she knew before her interrogation that her grandparents had reported their guns stolen as part of an apparent burglary, the erroneous admission of Officer Friedman's testimony was cumulative and therefore harmless beyond a reasonable doubt. And then finally, although Dr. DeMarte's testimony directly contradicted Dr. Samuel's opinions, Dr. DeMarte did not testify regarding premeditation or otherwise opine Arias had clarity of thought and an opportunity to reflect before killing the victim. Indeed, she strictly limited her testimony to Arias's mental state and behaviors after the killing. Rule 704 does not preclude expert testimony from which a jury might infer that a criminal defendant did or did not possess the requisite mens rea. The rule only precludes expert testimony of an opinion or inference that the defendant did not have the requisite mens rea, and testimony of an opinion or inference which, if true, would compel the conclusion that the defendant did or did not have the requisite mens rea. Therefore, the Superior Court did not abuse its discretion by admitting the expert testimony. And in that opinion, her conviction and sentence were also affirmed. Okay.
So is she done now? Is she
No, she has a potential state post-conviction claim, which is it hasn't been filed yet. It's in the pre-filing procedural stage in the Arizona courts. There is a hearing scheduled this month, I think maybe the 17th. But we won't know anything until after that hearing.
Gotcha.
And they'll either set firm deadlines for her to file her petition and the state to respond and, whatever, or they will kick the can down the street so that she has more time, and they'll schedule another status conference. That's why I didn't really go there, because it's only been 3 weeks and nothing has happened. But I wanted to make sure that I addressed the holdings in that second opinion, because the summary that I copied, I neglected to notice that it was not accurately a reflection of the actual opinion, that it was just part of the prior opinion. So then we have real quick updates. Oklahoma versus Julius Jones. The victim in that case was Paul Howell, who was shot in July of 1999, I believe. And my apologies, I should have put the dates for these cases as well. I just neglected to do that. I won't make that mistake again. To date, no legal action challenging Jones's conviction or the commutation of his sentence has been filed, although his family and advocates have continued their campaign of misinformation in the media. Carolyn Warmus, her victim, Betty Jean Solomon. As of today, there is still no result for the agreed DNA testing that was ordered in 2021, and there's been no court action filed to challenge Warmus's conviction or sentence based on results of that testing. And then Texas versus Frada, Price-Dash, and Guidry. The victim in that case was Farah Famide Bakr Frada. Frada was executed on January 10th, 2023. Price-Dash and Guidry remain on Texas death row, but there are no additional legal challenges to their convictions or sentences. Anthony Sanchez, Oklahoma versus Anthony Sanchez, Julie Buskin. On September 20th, 2023, Sanchez's new attorneys filed a petition for writ of certiorari to the U.S. Supreme Court, challenging the federal court's decision denying Sanchez's request for a stay of execution, requested in light of the court's delay in removing prior counsel, who they allege had abandoned Sanchez. At the same time, Sanchez's new counsel filed an application for stay of execution to allow them to review prior counsel's file and investigate potential claims to be raised to challenge Sanchez's conviction and sentence. On September 21st, 2023, the petition and request for stay were denied. Sanchez's execution went forward, and he was pronounced dead at 10:19 a.m. on September 21st, 2023. The return of his death warrant was filed on September 28th, 2023. And, his advocates are still saying, well, Glenn Sanchez confessed, so therefore Glenn Sanchez is the real murderer, and we just can't trust the DNA that said Anthony Sanchez was the only person who murdered Julie Buskin. And there was no DNA from Glenn Sanchez. So that's our updates for combination of season 1 and season 2.
No, that's a lot of good stuff.
And there are some cases that we talked about in season 1 that, I didn't really do anything because there's nothing going on. And I didn't talk about them. And then like the U.S. Supreme Court, I didn't talk about that because that's a whole another exercise. So, all right. So some of the cases that we may or may not look at in season 3, because I had a really cool list for season 2. And when I looked at it, I realized, well, dang, I hardly did any of those cases. So I promise people that in season 3, I'm going to consult this list when I am in the process of picking be able to get to some stuff, cases. And also, these aren't in any particular order. But again, if listeners have suggestions, my only requirement is it has to be a case that is at least concluded direct appeal. I want to be able to get as much information from court records as I can. And I want the conviction and sentence to be final when I talk about it to the best of my ability. So some of the cases I'm thinking of, we've got, it's on yours, I think. It's not on mine. The next case is going to be State of Maryland versus James Allen Kobicki. He was convicted of murdering a girlfriend who was pursuing him for child support for their child. And he's had quite a run through the Maryland and federal court systems. He's had his conviction reversed and retried. He's had that conviction reversed and reinstated by the U.S. Supreme Court. And he is currently on trial a third time. So we're going to look at the case up until the last reversal in 2020. And then we'll look at it again after that concludes with either an acquittal or direct appeal. Conviction, direct appeal. Then we've got State of Tennessee versus Janet Elaine Hines. And that deals with the terrors of driving while drunk. State of Oklahoma versus Scott Eisenberg. He was it was an Oklahoma execution that had a lot of noise around it. So kind of like Cottingham. State of New Jersey versus Melanie McGuire. State of Florida versus Dahlia DiPolito. State of Texas versus Linda Anita Carty. Gottlieb Peterson, Adnan Syed. State of Florida versus Danny Rolling, State of Ohio versus Elwood Jones, which I think, Kyle, is one of your cases, right?
Yep, that's right.
Okay. And is that an innocence fraud or a potential innocence fraud one?
I don't think so quite as much, maybe a little bit, but I don't think to the same extent that a lot of these are.
Okay. And then State of Missouri versus Charles Erickson. Um, I don't know if I have because of Kathleen Zellner's involvement, I don't know if I have the emotional bandwidth to deal with Ferguson.
And she hasn't gotten Stephen Avery out of jail yet either, has she?
No,
After she promised she
no.
was going to. She was convinced that
She's
she was going to get him out of jail.
she's just filed another appeal. Um, at State of Florida versus James Daly, State of Florida versus Ziegler, which I think is another one you suggested.
Yep, that's right.
I can't remember. What is his first name? He's the one that,
Oh, I'm having a senior moment.
or is it State of Illinois versus Ziegler?
Oh, I'm having a senior moment. I'll have to go
Okay.
back in my notes and look. I'm sorry.
Oh, no
I should
problem.
be able to remember that, but I cannot. It's not popping in my head right now.
And then we're going to look at State of Michigan versus Frederick Freeman, aka Temujin Kensu. Um, and I probably am going to disagree with Rob Chadwick because I think he's the one who we briefly talked about this one. I don't know if you're familiar with the case or if you have any opinions about it.
No, that is not one I'm as familiar
Okay,
with.
thank goodness you and I won't have to fight. State of Oklahoma versus Philip Dean Hancock, because I just, in light of McDougal and Humphrey's partial brain cell and their little histrionics before the media, I am going to show
Right.
listeners why that was not self fucking defense. State of California versus Phil Spector and State of Florida versus Ashley MacArthur. Of course, we'll also look at innocence fraud cases. If and I have to, warn listeners, sometimes I will start the research on a case and then it will in some way, shape, or form trigger me and I won't be able to deal with it anymore. I will never look at Casey Anthony again. I looked at it once, it disgusted me. I can't do
Yeah.
it anymore. OJ
Yeah.
Simpson, can't do it anymore. Even though I was doing something different at the time, I just can't deal with it. So, but, and then we'll also do the USSC case review. We'll do the post 2010 cases as well as the ones that I missed in my original research. And so, do you have any other cases you'd be interested in?
I think those are the big ones. I think I need to go back and look at my notes. There may be one that I need to, oh yeah, there is one I'll follow up with you offline that we should look at. But I think the issue with that though, I think there are a couple I've thought about, but I don't think they're fully on the appeals piece, which I think was kind of what made it tough. But there are a
Yeah,
couple I'll
yeah.
flag for you. Maybe we can look at.
It's, Casey Anthony's a little different because Florida records were pretty easily available online. So I had the court opinions,
Right,
the trial court opinions, and I had the briefs by Casey Anthony in the state to rely on. And it's when you have like an unsolved case, most of your research is in the media. And
yep,
so you are basically, you only have that side of the story, whatever one they decided to report. You don't have necessarily a refutation of their facts from other sources.
right.
which you see a lot of times, like especially in post-conviction, you can read a federal writ of habeas corpus, and then you can read the state's response, and you can see every fact raised refuted.
Right.
Or, a challenge to those facts. So that's why I prefer to do it the way I do it. And we'll always try to do it that way with very few exceptions. So, but
No, that
yeah,
makes sense.
anything people mention, and if I get a case where I just can't deal with it, I'll say, well, I'm not going to look at that one anymore. I changed my mind. So, but yeah, follow up, email me with any list,
Yeah, absolutely.
any list that you have. And, it just, like I said, it depends on how much is out there. And, like the Delphi case, I want to wait for it to play out in
Yeah,
court. The Idaho case, I want to wait for it to play out in court,
right.
trial, and at least direct appeal
Yeah, exactly. That makes
before
sense.
I try to digest it. Because there are just so many things we don't know. I mean, I think, were you and I the ones who talked about the roommate who saw the
Yeah,
intruder?
we did. I still can't wrap my head around that.
Yeah. But she, like I said, she may have explained it to police, and it just hasn't made it into the media yet.
Yeah,
And
but
she hasn't directly explained it to the media herself. But we may see at trial that she testifies, well, this is what happened,
yeah, then it'll make more sense.
because I don't see why she saw him. If he saw her, he would have gone after her.
That's what, yeah, I thought the same thing. That's what I can't, I don't know, it just doesn't make sense to me.
And,
A weird thing.
but I also take it, though, sometimes college kids living in a house together, they all lead separate lives. And so, I don't know how close she may have been to her other roommates, but it's almost like people living in an apartment complex in their separate apartments. And you may see something that you don't really think is fishy at the time.
Yeah.
But when dead bodies turn up, then it becomes significant.
Well, I don't know. I still think it's weird that nobody called the police for what, 4 hours or whatever it was, whatever that time period was, just seems
Yeah.
really strange to me.
But again, I would think that she would have been suspect number one if she didn't have a good explanation for that,
Right. Yeah.
you know. But again, we'll see how that I
Yeah,
want to
it'll be
see how that
interesting to
plays
see how
out.
that plays out. Yeah,
So,
absolutely.
um all right, well, I think we're gonna pretty much we've got it all.
Excellent. Well, thanks
We're
for all your work.
done.
Happy New Year, and we will talk
Thank you.
soon.
Happy New Year and
Thanks
have
everybody
fun
for
tonight.
listening. Yeah, will do. Hopefully I will do better than the Cowboys, which are not doing very well in the playoffs. It's become
Well,
ugly very quickly.
as
But
a
I
as
knew
a
when the
lifelong Saints fan, I can't be mad about that.
I knew when they drew the Packers, it wasn't going to be good. The Packers have just had their number, so it was going to be rough. Oh, well, take care.
Well,
Have a
you
great.
know what?
Yep.
I don't like either team.
There you go. Fair enough.
So I don't know how to feel.
Well, yeah, I know. It's like which one's the worst of two evils?
Yeah, the worst of two evils. All right. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'Brien LN. Kyle and I will return in 2 weeks for episode 2, State of Maryland versus James Allen Kolbicki. Kolbicki was convicted for the 1993 murder of his former girlfriend, Gina Marie Nolson, who was seeking court-ordered child support for their son. We'll talk about the twists and turns in Kolbicki's case including the reinstatement of his conviction by the U.S. Supreme Court and the 2020 order of the Maryland Court of Appeals granting Kulbicki's request for a certificate of actual innocence. Until then, have a safe 2 weeks. Good night.